Welcome back to OGE's training on 18 USC 208. Today we are going to apply the concepts from the previous training. Next slide. As we discussed in the previous training, it's important to use the elements of 18 USC 208 as a checklist when evaluating situations that may implicate conflicts of interest concerns. All of the elements need to be met to establish a 208 violation. Next slide. Throughout the exercises today, we're going to start with this simple fact scenario and change the facts slightly a number of times so you can see how the 208 analysis changes based on the specific facts presented. The initial scenario is Sandra is an attorney at the FTC who's assigned to begin work on an investigation of Apple. She owns $20,000 of stock in Apple. Supervisor wants to know if this presents any issues. Next slide. So now we're going to apply the checklist. First, Sandra is an officer or employee of the executive branch since she works at the FTC. She is participating in a particular matter. An investigation is an example of a particular matter involving specific parties or a party matter. That matter would have a direct and predictable effect on the financial interests of Sandra because she owns stock in the company being investigated. And as one of the attorneys on the investigation, her participation is almost certainly not just ministerial, but personal and substantial. And Sandra knows that she owns stock in Apple since she disclosed this information to the ethics office during a conflicts check. So in this case, all of the elements are met, and this presents a 208 issue. If she were to move forward, Sandra would likely violate 208. Next slide. Of course, just identifying the issue is only half the battle. You, as the ethics official, next need to determine how to resolve the 208 problem. As discussed earlier, once a 208 issue is identified, the first step is to recuse, so Sandra does not begin work on this investigation in the first place. There are two major options if the agency wants her to work on the matter. First, Sandra can divest. She can sell the Apple stock, which completely cures the conflict. Second, the agency could potentially issue an 18 USC 208 B1 waiver. The appropriateness of a waiver depends on a variety of factors, including the amount of stock in her portfolio. So, is this Apple stock 20% or 2% of Sandra's portfolio? And the importance of the employee to the investigation. Does Sandra have specific expertise needed to fulfill the FTC's objectives in this investigation? Those are all the issues an ethics official should be thinking about when presented with this basic fact pattern. Now let's change up the facts a little bit. Next slide. Okay, in this version, Sandra only owns $10,000 worth of stock in Apple. Next slide. So all of the elements are still met, but Sandra now qualifies for the DeMinimis exemption. So 208 does not apply in this situation. She is exempt from 208. As the ethics official, you will still need to advise Sandra to monitor this holding to make sure she does not exceed the de minimis threshold, but no further action is needed. Let's tweak the facts a bit again. Next slide. In this version, Sandra doesn't own stock in Apple, but her spouse works there and likely has some employment related assets too. How would you evaluate this set of facts? Next slide. So again, all the elements are met. since the employee's spouse's employment interest is imputed to the employee. But this is much harder to resolve. Generally, it's difficult to cure the conflict as the employee's spouse won't quit her job. It's difficult to ask the employee's spouse to do that. This would also be a difficult candidate for a waiver, since this is a very significant financial interest for the employee and her spouse. Most likely, Sandra is not going to be able to work on this matter. Recusal is the best option here. Next slide. Let's change the facts a bit again. In this scenario, the employee isn't working on an investigation into Apple, but instead a regulation governing the energy efficiency of consumer electronics. How would we analyze this version? Next slide. Using our checklist, the thing we want to focus on here is the definition of particular matter. A rule regulating consumer electronics in particular would be considered a particular matter of general applicability affecting a discrete and identifiable class in which Apple is a part. So 208 applies again, and we're looking at recusal, divestiture, or waiver again as remedies. One note here is that a waiver might be more appropriate for a particular matter of general applicability rather than a party matter, since the matter is not just focusing on the one company where the employee has a financial interest. Next slide. So, what if the regulation the employee is working on is a tax regulation that will affect all businesses? Next slide. And the key difference here is that this would be just a matter, not a particular matter, since it does not focus on either specific parties or a discrete and identifiable class. 208 would not apply here. Next slide. Okay, finally, this is the trickiest twist. What if the attorney does not have any financial interest in Apple, but does own stock in a company that does business with Apple, such as, for example, a company that makes parts that Apple uses in its hardware? Next slide. It would be difficult in this case to clearly establish that the particular matter would have a direct and predictable effect on the employee's financial interest. However, ethics officials should still consider impartiality issues and appearance issues and counsel the employee accordingly. We're not going to get into those analyses here, but it's important to keep in mind. Next slide. This concludes the applied portion of our 18 USC 208 training. Please remember to reach out to your OGE desk officer if you have any questions. Thank you for your attendance and your attention. Have a great rest of your day.